Good morning, everybody. Big hello and welcome to this webinar. My name is Alex Kiernan, and I'm one of the partners here at Thomas Mansfield, and I'm going to be hosting the discussion today. I am very pleased to be joined by my esteemed colleagues. We've got Meredith Hurst there.
Hello.
Meredith is one of the fellow partners within the firm, and we've got Alison.
Good morning.
Morning, Alison, who's one of our associate solicitors. Alison has gone beyond the call of duty this morning. She's had an internet problem, so she's had to move to a new location. So well done, Alison. Before we begin, just because I know we've got quite a few new attendees here today, I wanted to just give you a bit of background about the firm. Thomas Mansfield began as a specialist employment law firm, and that's still a big part of what we do. But we've also grown into a large family law department. We have a dispute resolution department now, so dealing with civil matters. And we have a growing wills and probate department as well. In the employment team, we tend to generally deal with organisations and companies of all sizes, respondent work. And often we're advising senior HR managers. We're often working with line managers in businesses and also those business owners, which is really frequent as well. So we're proud to say that we provide a real sort of full range of employment law support as well as in other areas of law. And it's worth saying as well, we also work with a number of sort of senior executives and employees. So what are we going to be doing today? Well, we're going to be exploring effective ways to manage performance. Really common issue, clearly, in the workplace. We're also going to touch on its interaction with conduct-related disciplinary matters. And as part and parcel of this, we're going to look at some of those commonalities between performance and conduct, as well as some of those differences that occur. So, I think today should be quite an interesting discussion. If I could ask as well, I think it's really important and useful for us, if you have any questions as we go through, we have a chat box. If you look on your window, on mine, it's on the right-hand side. There's a section there, chat. Click on that. There's a little box at the bottom, and you can ask any questions. I'm in charge of the IT today, slightly frighteningly. So I will be keeping a lookout for any questions on there, and I'll sort of jump in at points and try and put some of those questions to our panel. So what I thought we would do is start with a short poll, just to kick things off. Then I'm going to be moving into asking my colleagues to outline some of the basics, and I'm looking for their insight into how an employer builds strong foundations, looking at key management steps in this area. And then we're going to move on to looking at fairness of procedure and performance management overall. So without further ado, let's just put up a poll quickly. Put this on. So hopefully everyone should be seeing that. And the question here is, which of the following is not a potentially fair reason for dismissal as defined by law? Got some answers coming in. I'll give you a couple of minutes and we'll see where we get to with it. I think we must have quite a lot of HR people in today because or maybe we've made this question way too easy. Oh no, there's a bit of variance now. All right, perfect. Right, well, I'm going to run the poll there. We've got about 70% of people saying competence is not a potentially fair reason for dismissal, and we've got about 30% saying capability. It's a big part of what we're going to be talking about today. So capability is a performance-related dismissal, and that is a potentially fair reason. Conduct obviously is a potentially fair reason. So its competence is the sort of joker that we've picked out there. And most people got that. So well done. So without further ado then, moving on to matters. Alison, if I could bring you in. Can you just set out for us some of the sort of basic principles surrounding dismissal and its impact on
Alex.
capability?
Morning, everyone.
So the right not to be unfairly dismissed and to bring a claim for what's titled ordinary unfair dismissal is only available to an employee. So that's somebody who works under a contract of employment, someone who has been dismissed, and someone who had completed the 2-year qualifying period of service before that dismissal. As many of you will know, there's also a broader category of worker, and that's those whose contract isn't a contract of employment. To touch on it very briefly, they wouldn't generally have legal protections from ordinary unfair dismissal. And then the same, of course, applies to employees with under 2 years service. However, in practice, it may still be preferable to follow the steps we're going to outline for all your staff as a safeguard against allegations of claims people do have the right to bring. For example, discrimination if you're dismissing an individual for their performance or their conduct with no process whatsoever. Often you're going to need to take a commercial decision about that at the time based on the perceived risk to your organisation. And I think it's an important area to seek legal advice on if you have any concerns at all. In some circumstances, a worker can still bring a claim they've suffered an unlawful detriment because of the termination of their contract. For example, if their termination relates to discrimination or to whistleblowing, or they argue that it does, and no qualifying period of service is necessary to claim whistleblowing, detriment, and a range of other so-called automatically unfair dismissals, as opposed to ordinary unfair dismissal. Those claims don't require the employment tribunal to consider the reasonableness of the dismissal if the employer's motivation can be proven. So it's often, therefore, best, as we say, to follow a thorough procedure in any case where you're dealing with poor performance or misconduct to minimise the risk.
Thanks, Alison. So to pick out a couple of the themes there in terms of what you've mentioned. So you've mentioned these potentially fair reasons for dismissal, and you've also talked about this ordinary unfair dismissal. Are you able to elaborate on those?
Absolutely. It's not a simple topic. It's for the employer to show that the reason or the main reason for dismissal is one of the 5 potentially fair reasons. And that's what our poll this morning related to. The 5 reasons are capability, conduct, redundancy, breach of a statutory duty or restriction, or what's called another substantial reason warranting dismissal, which is a catch-all for situations like a business reorganisation. So identifying, communicating, and clearly documenting the reason you are going to give is important, because dismissing for a reason that isn't in fact the true reason can put you at risk of a finding of unfair dismissal. For example, when someone's performance is falling short, but instead of tackling a difficult conversation about that, the employer makes the person's role redundant and uses performance to mark them down in the selection process.
Mm-hmm. I think that's really true as well. I think it's really common that we come across an employer sort of misunderstanding and mislabeling what the reason for dismissal is. So it's really important at that early stage, as you say, to consider it. So coming on to that then, Meredith, we've talked about capability and conduct. That's the theme of today as being one of those 5 reasons. What's the legal test in respect of those elements?
Well, certainly, I'll outline that. I mean, there are some similarities in the process in preparation for performance and conduct, which we'll come on to. And that is because the overall legal test applies to both. And namely, that's that you must hold a genuine belief in the reason that you're relying upon. So you can't rely upon a mere suspicion. And that belief must be based on reasonable grounds. So before you arrive at that genuine belief based upon those grounds, you must have carried out a reasonable investigation. And so in the context of performance, that amounts to a proper exploration of the problem. Having then identified the reason, you must follow a fair procedure. And so there's 2 main sort of components. One is the substantive fairness, as we call it, so holding that genuine belief, and then the procedural fairness as well. In the context of dismissal for capability reasons, what the tribunal will also wish to scrutinise is whether management have failed to discharge its own responsibilities towards the employee. An important element of that will be the extent to which the business has clearly communicated the requirements of the role to the individual, or where applicable, has provided necessary support and training. And we'll come on to discuss that in the context of the basic foundations.
Perfect. Thanks. And I think I'm conscious we keep mentioning the word capability. Alison, what do we mean by that?
Yeah, absolutely. So capability in this context means the capability or the qualifications of the individual to perform work of the kind they're employed to do. So the people who said competence might be a fair reason were on the right track because it would fall within capability, which is what the law is going to call it. So looking at the legislation a bit further, they define those points by adding that capability is assessed by reference to the skill, the aptitude, the health, or any other physical or mental quality of the employee. And qualification means any degree, diploma, other academic, technical, or professional qualification that's relevant to the position they hold. So it's worth pointing out there the reference to health in the definition. We're going to focus on performance aspects today, but health certainly can be a required attribute in a role. So for example, in the transport industry, if you have someone employed to drive and they lose their driving license because of medical condition, then, subject to factors such as whether alternative non-driving duties are available, a dismissal on that basis could potentially be fair. And then when we talk about capability today, what we're really going to be considering is performance based on skill and aptitude, because that's what we see, most as an issue for our clients.
Thanks. Okay, so those are the kind of basics then. So Meredith, we spend a lot of time saying to clients, look, you need strong foundations on some of these aspects. What do we mean by that? What are some of these strong foundations we talk about?
As we know, capability and conduct are ripe for conflict, areas ripe for conflict in the workplace, not least because you are challenging someone's, I suppose, the essence of somebody's ability or their behaviour. And it's very important to set the required standards at the outset, and that will vary from role to role, encompass not only the technical aspects of the job, but the more subjective things such as the employee's attitude or their ability to interact with clients and colleagues. Now, setting standards sounds easy, doesn't it? But it isn't necessarily. It might be relatively straightforward in, let's say, a sales environment when concerned with measurable financial targets. But even then, it can be quite a high-stake emotional environment and quite high-pressured. And in a job like ours, to use an example of the legal world, work quality and client management can be as important as income generation, target meeting, and it's going to be difficult to assess overall. So it might be a case of monitoring work on an ad hoc basis, and that's why you might have a sort of direct supervision process in place. So a partner, solicitor supervision relationship. In an ideal world as well, you will have a solid infrastructure to monitor performance, and we'll come on to some of those aspects as well. There are some things you should have in place as a matter of course to make your life easier as managers. Standards of performance are not static, and so and they're also liable to change as the business or the role evolves or new technology or equipment is introduced. So the contract of employment needs to be kept up to date. The appropriate performance standards are judged according to the employee's current contractual requirements and role. Probationary period is obviously important at the outset. Now, that's only going to help you in the early stages of the employment relationship, but it's an ideal time for you to assess a person's suitability for the role. And if the employee doesn't perform to the satisfactory standard during that period, then you can dismiss, and you don't have to wait until the end of the probationary period before doing so. Of course, at the end of the probationary period, if performance has been satisfactory, then you confirm that. But it's important in any dismissal, in my experience, notwithstanding that it's a probationary dismissal, to still document the reasons with as much detail as you can, so as to be in a position to rebut any suggestion of discriminatory or unfair treatment. I don't think it's particularly helpful for an employer to say, well, we don't need to give you a reason because you're in your probation, because that will lead to that lacuna or that thought in the mind of the employee that it must have been for some other impermissible reason. An induction program can be of use to help the employee navigate your systems, your processes. You can monitor things like whether you've given them a copy of your handbook, whether they've had sight of the email and internet policy, and that will help at that stage. Now, of course, management processes and proactive employee management are vital to ensure performance is maintained, as well as conduct, and that can include regular one-to-ones and appraisals to demonstrate the reasonable belief that an employee is incompetent or that they've committed an act of misconduct subsequently, so as to justify action. If it comes to that, then you do need to be able to produce some evidence of poor performance or conduct when you reach that stage. And a performance appraisal is going to be helpful if diligently pursued. That can provide important evidence of performance problems and can be used subsequently to support a fair dismissal. And now something managers shy away from is conducting appraisals honestly. Now, it's counterproductive to provide unduly positive or flattering feedback, which doesn't reflect the true performance, because you'll find that you're hampered by that later. So that's where management training comes in. It's vital to provide managers with knowledge of your procedures and competence to implement them. An employment tribunal isn't going to give you any credit or look upon you favourably for having policies, a performance management or disciplinary policy in place, if their managers, when cross-examined about it, don't understand it, haven't read it, and don't know how to apply it. In the worst case, didn't even know it existed, which has happened in a case that I've acted on. And you might also set standards of performance in non-contractual procedures. A couple of clients have best practice do's and don'ts document. A recruitment client has an etiquette recruiters document, and they're things that are presented to the individual with their contract. So I think that's a helpful overview of the basic foundations.
That it really is, and I think there's a lot there. I was just taking down a note of some of the key aspects. So we've got sort of set standard, that often is referred to as setting those values in your organisation. We've got have a good contract. I think that's hugely important. We've got use a probationary period. So common that people just have them in the contract and then don't manage the person. Think about inductions and management training. I think that is such an important point, because again, it's such a key element. If you can have all the position, measures in place, but if people aren't managing and actually giving that constructive, honest feedback, it creates problems. So, Alison, let's say you've got all of that in place, done really well. What if this performance issue still arises?
So the first thing to consider is whether there is a problem, which is less flippant than it might sound. And if so, to drill down into how it presents. Poor performance can take many different forms. Some common examples would be a lack of productivity, inflexibility, failing to establish or maintain good working relationships with colleagues or with customers. As we mentioned, do be careful that you fully consider and categorize the reasons you're taking action at the outset of any process. Sometimes, for example, capability might be better categorized as conduct if it's really down to the individual's choices and behaviors. The Employment Appeal Tribunal has helpfully commented that capability should be interpreted narrowly and strictly. Cases where a person's poor performance is due to carelessness, negligence, or what they call dilatory approach to work might be more appropriately termed misconduct and might be dealt with as such.
Okay, so are there any sort of complicating features at this early stage we need to factor in, Alison?
There are. It's important to look behind what you might initially see when an employee presents with performance issues. You can't always take that at face value. When you're investigating, employers sometimes find there are other serious issues they need to address, either instead of or in addition to the alleged poor performance. For example, there might be ill health or disability, might be problems with childcare or other caring responsibilities, poor management within the team, harassment or bullying, or perhaps an excessive workload that's leading to an inability to realistically deliver and placing stress on the employee as well. All of those would fairly need to be addressed by the employer before treating the employee's performance as a central issue or starting to consider their dismissal.
Perfect. And so if I asked you then to just outline what would be your key advice steps at this initial stage of a poor performance process?
Yeah, I will break it down as clearly as I can into some basic steps. So number one, deal with problems early. Addressing performance issues as soon as they arise is really important from a legal perspective. It's also probably the right thing to do. It can be the best path for the employer and the employee. An employee is much more likely to improve their performance if concerns are highlighted early, when they're manageable, rather than being left to grow and fester. Training and support to improve performance can be less time-consuming and less costly than going through a dismissal procedure, having concerns about potential legal claim, and then following a recruitment process for a replacement. And then being able to demonstrate that an employee is being given support and the opportunity to improve will also increase the likelihood that a tribunal will find that any dismissal was fair. So then number two, don't avoid the problem. Kind of the same thing, but not quite. Confronting an employee over their poor performance can feel daunting for some managers. they might tend to let things drift. Others might just want to avoid what they see as a time-consuming performance management process. They may feel they don't have time in their day to add that in as well. But performance management is an important aspect of maintaining positive performance and morale in the workforce. It's important that employees are clear on what's expected of them. And it can also be demotivating for the productive members of your workforce if the underperformance of their colleagues is ignored. And then number 3, pay attention to record keeping. It's important that you keep records of all the feedback that's given as part of day-to-day management. You may need it in the future, but do note, though, that any informal warnings that are given as an early stage shouldn't form part of an employee's disciplinary record as such.
Perfect. That is really helpful. I was about to move on, Meredith, to ask you about sort of an informal, formal processes, but actually we have a beautifully timed question that's come in. So one of the question that's come up here is, if HR have been informed about some performance or conduct issues in a probationary period, would you expect the manager to have a meeting with them before HR are present in that meeting as part of the probationary review? I think that's really well timed, because my answer to that, and I'd like to get your comments on it as well, Meredith, is, well, yeah, I would expect, if there's a performance issue, then I would expect that manager to have already having discussions with that individual, like we've spoken about, at an early stage themselves. I don't think they need to have HR there. I think most of the time, early stages, they probably shouldn't have HR there unless they're really serious. I think.
Yeah, I think so. Yeah, I mean, visual, I suppose from an optics point of view, once you've got HR involved, then it's more serious. But on the other hand, can the business trust that particular manager? The manager may say something injudicious, and you may then be unraveling another problem. I mean, my suggestion would be, if management have concerns and you have an HR department, maybe for the manager to approach HR for some guidance before they have the conversation, possibly. But it comes on to what I was going to talk about in terms of an informal process. So the short answer to that is yes. I think that the manager could, provided the manager is somebody that is in a position to do so, has the wherewithal to do so, and there's no harm in that manager getting some guidance on how to have that conversation. I think that's important. Sensitivities around this area. So hopefully the aim of any process that we're communicating, be it formal or informal, is to assist the employee to reach the required standards of performance. And that informal process at an early stage can, as can dealing with issues early, as outlined above, help. In some procedures, mandate or require an informal discussion first before proceeding to a more formal stage. The gentler informal approach can be appropriate in cases of minor performance breaches, and again, to use a sort of legal context, minor drafting errors in a document which don't have any sort of legal outcome, don't have any significant liability ramifications. You'd sit down with the individual and work through the document with them, encouraging them to check their work in a different way, for example, or suggest that another colleague proofreads the document, and that's an example from the real world. The informal approach, a soft approach, also avoids the risk of an allegation that you've been heavy-handed, discriminatory, or that you've harassed the employee, and it is a sensitive subject, of course. What does it look like in practice? Well, the question we've had in really is the answer to that as well, if you like, that it will entail speaking to the employee about a specific task at the time, and it goes back to what Alison said about not avoiding the issue, if their standard of work is below par. In other words, tackle the problem early. And again, delay here will make it more difficult to rely upon it in circumstances where you want to show that there's been an accumulation of material to establish poor performance later on. So you're nipping the problem in the bud there.
Yeah, no, I completely agree. All right. So let's say I'm a business owner. I've tried this softly informal approach. Let's say I'm getting a bit frustrated at this point. Things aren't changing. Meredith, what are the sort of practical steps I need to do then before I embark upon this formal process?
I think there are some things you probably start to think about. And obviously the first thing I'd probably reach for is your capability or your conduct procedure, if you have one. Make sure you know where it is and what the steps are. And whilst we don't necessarily slavishly adhere to it, I think it's good to have that in the back of our mind, and also the ACAS Code of Practice, which on disciplinary and grievances, which also deals with capability and should be adhered to. give thought to practical timing. Absences, is the manager away? Is the individual that you're concerned about away? So are there any absences which may impede the process? Check your policy on the right to be accompanied. I mean, if you're embarking on an investigation in a capability context, then there isn't necessarily the statutory right to be accompanied at an investigation. The right to be accompanied bites at the hearing stage, the disciplinary or conduct hearing stage, not the investigation stage, but decide whether to allow that for somebody who may be vulnerable or have some form of impairment. Also check your policy on recording meetings. Now, some policies make it express there that recordings are prohibited. If an employee wants to record the meeting and you've got a competent manager dealing with it, then I would say do so. You have nothing to hide. It will only record what is said. And of course, we now, in the current climates with smartphones and so on, are finding more and more that employees are in any event recording. And that's a good reminder to think about what you're saying as you're in the meeting. It's becoming very fashionable, as I say, for employees to make clandestine recordings, to make clear to the individual what you will allow in advance, essentially.
Yeah, fine. I think recordings has become increasingly a big issue, as you say, so it's definitely something to watch out for. And it's quite interesting, I think, that the tribunal, just to cover it off, what they tend to say is, well, it's very naughty of you to have recorded that, but in reality, we're now all going to listen to it if it's relevant to the claim. So it's one of those funny ones. Okay, Alison, can you take us through what would be the basis of this reasonable investigation that Meredith was just mentioning?
Yeah, absolutely. So we've considered the importance of establishing that performance concerns exist and that you have a genuine belief in poor performance before you take any action. It's all the more important when you're embarking on a formal process that could lead to dismissal. However, as the leading case on dismissal tells us, it isn't necessary for you to prove that someone is incapable or incompetent. What you must establish is a reasonable belief. It's not criminal standard proof. There's no need to establish the position beyond or reasonable doubt. You must have that reasonable belief. To satisfy that test, there's going to need reasonable evidence of poor performance. So, looking at things like appraisals, work examples, you can't establish a reasonable belief based on anecdotal examples or suspicion or, perhaps in lots of cases, just a manager's view. And I'll add that that's all the more important in the context of conduct, but, we'll keep to capability for now. So then when we come on to the basics of a reasonable investigation, we have help here from the ACAS Code of Practice on Disciplinary and Grievance Procedures. That emphasises the importance of investigations, providing the employee with the findings and allowing them the opportunity to respond. And these are the principles of what we would call natural justice. So you'll need to gather your evidence and your rationale. You'll need to show what your expectations are for the role and how the individual hasn't met them. That's invariably going to mean a discussion with the individual's manager, possibly accompanied by HR for support. You're going to want to record practical examples of inadequate performance, as well as their wider feedback on the employee in the situation. The investigation is almost always going to involve interviewing the employee themselves, presenting them with the evidence you have to comment on. When you're holding an investigation meeting, there is no legal right for the employee to bring a companion, but you might choose to allow it in certain circumstances, for example, in the case of a vulnerable employee. And then it also wouldn't be common to involve witnesses in a capability case in the way it might be in a conduct situation. It should be, easier to measure and show performance. But it's important to consider every case individually. And if the employee refers you to specific witnesses they consider relevant, do consider interviewing them. And if you decide not to, make sure you have a good reason and record it. And then full notes of the investigation, including any notes you take during meetings, need to be retained for future reference. And you'll need it, of course, if the process does unfortunately result in a tribunal claim.
Perfect. And so what is it? Okay, so you've done that aspect of things, and then what does it look like for us in terms of a formal capability review?
So I'm going to cover here what we would call using a performance improvement plan. I think, that's a common term. It's how many employers consider it as a sort of formal way to approach this, quite a well-trodden path. If once you've considered the results of the investigation, you decide it's right to proceed with a formal requirement that the employee show improvements in their performance or the results, you're probably going to want to move to a performance improvement plan of some type, I'll call it a PIP. Generally, you'd prefer a performance improvement matrix or a plan document. You'll probably need to work with the employee's manager on setting what are called SMART objectives. So that's objectives that are specific, measurable, achievable, relevant, and time-bound, because that's how you'll make sure they're fair, and that's how you'll measure them and decide whether the standard's been met. The PIP document is going to map out the process. It's going to include the performance concern or the concerns, the level of improvement that's going to be required, the timescale for the individual to meet the required standards, and a program for intermediate monitoring during the period. You're then generally going to write to the individual, invite them to a formal meeting, so that you can discuss the situation and set out the next steps with them.
Fine. And so you'd normally write to them, would you? Is there a particular format that we've got to follow, or?
Yeah, but I think it's one of those steps that's important to take in writing. And by writing to them, I don't necessarily mean a letter to their home address, but you're going to want that to evidence it if you ever need to in the future. So first, you need to make the purpose of the meeting clear. It's a meeting to consider the employee's performance and whether it's fallen below the required standards. Don't bring anyone to a meeting and then spring this on them. Secondly, you should clearly state that you will consider and you'll discuss the reasons for the alleged poor performance in the meeting. You should also set out your initial investigation findings in a letter, provide reasonable evidence. For example, if the employee is showing poor productivity, you might attach their timesheets, their sales figures, all of those things you've collected to assist you, provided they show the performance concerns. Obviously, the nature of the evidence is going to depend on the role and the situation. You may want to work in collaboration with the manager on that. You'll also need to refer to and potentially include relevant company documents, that back up your standards. So the employment contract, up-to-date job descriptions, which you should have, training records, which you should have, performance appraisals, your staff handbook, operating procedures, any previous action plan. It will all depend on your business and the role. You should also offer the employee an opportunity to provide any further documents that they consider relevant. So I'd recommend giving a deadline for any further information, because you don't want the matter to drag on and you'll need time to review it in advance of the meeting. You might need to consider whether the employee needs access to the company's systems or assistance finding something to prepare their case. You may need to explain the mechanics, you may need to assist. You should also outline the possible sanctions in that letter. So those might include a first written warning, accompanied by a requirement for improvement in the performance plan we just touched on, or a final written warning. Although I would say a final warning for performance is unusual outside of serious incompetence, but we'll sort of come on to how the process may wrap up in a minute. So you should also confirm who's going to be conducting the meeting and their role, as well as the presence of a note taker or an HR representative if you're going to do that, which I think is ideal, but not always possible. So while capability isn't generally considered a disciplinary matter, and it's best practice to have a separate disciplinary and capability policy, it's generally best to allow an employee to be accompanied by a colleague or a trade union representative at a meeting that may result in a formal sanction. It's something the tribunal generally wants to see as part of a reasonable process. And finally, it goes without saying that it's a good idea to restate the company's own performance management process in this letter. What will the next steps be? It demonstrates how you intend to comply with it, and you should attach a copy of your process with the letter. Final point, do note that the ACAS code requires that the meeting is held without unreasonable delay, but not so quickly that the employee can't prepare their own case. That's really going to be, again, as I keep saying, fact sensitive. Refer to your own internal procedure if it sets one out, covering timescales. In practice, there's usually a balance to be struck. A minor delay is a really significant issue, and it might not be reasonable to only allow an employee, 1 or 2 days to prepare. If in doubt, legal advice.
Perfect. That's really helpful. So, okay, so that's gone out. I invited in. So, in terms of the meeting itself, then Meredith, can you talk us through that?
The most important thing is to do what you said you'll do in your letter, essentially.
Yeah.
So it's sort of rehashing what you've outlined there. So you you must allow the employee to explain their position. That's the whole purpose of the meeting. In respect of each area of relation to poor performance, and the same goes for conduct, you're putting the allegation of misconduct to the individual. Principles of natural justice apply, obviously. So if possible, you should seek to explore and identify the cause of the underperformance. We have actually had a question in, which we may come on to, about aggressive interaction with colleagues. That individual saying that the cause is a neurodivergent condition. We can come on to that shortly. Is something like that the cause of the underperformance? Discuss with the employee the remedial action to be taken. Set a reasonable period for the employee to reach the required standard, and that will vary from job to job, and we'll come on to that shortly. Agree on a monitoring system during the period. So if you've agreed as a manager to sit with the individual during the initial review period, so that, let's say you issue a warning for a month or 3 months, ensure that if you're going to have regular catch-ups, if you've told them you're going to do that, then do so. Complete the PIP document or the performance improvement plan document with the individual during the meeting if possible, and require the individual to sign that to confirm their agreement to it. And inform the employee of the potential consequences of not satisfying the performance standards within the period.
Yeah, fine. And then, okay, so that meeting finishes then. Are there particular steps you'd recommend straight after that? What's the next? What's the next stage?
Yeah, well, you'll follow up with a letter. And tribunals like letters. They like to see that you've communicated things in writing. And outlining what you've agreed, not least because it's a record of what you've agreed. Issue the performance improvement warning, or what ACAS call improvement notice, for a specified period if your decision is indeed to do that. I mean, you may well find that having investigated it, you don't take any further action. And we were discussing earlier this morning whether you offer a right of appeal. And I looked into it, and it is best practice to offer a right of appeal against the sanction. Now, what that would look like potentially is another independent manager looking at it and deciding whether the first manager's decision to impose a warning for the performance concerns identified was reasonable. You should provide the completed PIP document if you haven't completed it within the meeting itself, specifying the agreed and expected performance requirements and timescales for compliance. And if you've kept minutes, which are useful, then they should also be provided. Having told the individual that their performance is going to be monitored and discussed during the review period, it is essential that you keep that process under review. And we have had 1 or 2 cases where there hasn't been any intermediate review during the warning period, and then it gets to the end of it and there's been really no interaction. It's very difficult then to say, well, that individual hasn't met the required standards, and that could render any subsequent dismissal unfair potentially. So the individual should meet with the individual manager should meet with the individual probably at least twice during the review period to discuss how they're progressing. So taking a back seat in that context isn't going to help you. Forgetting to hold those intermediate discussions could mean that, as I say, dismissal is unfair. If the individual's performance continues to fall short at the end of the review period, then the process will repeat effectively with a second invitation to a meeting at which you may decide to issue a further performance warning, and the PIP document will be updated. I think ACAS recommends at least 1 or 2 warnings before you consider dismissal. And then, of course, subsequent to that further review period, you may decide to dismiss or confirm their continued employment at a subsequent meeting. And there are alternatives to dismissal, which Alison is going to talk about in a little while as well.
Thanks, Meredith. And we've had another question come in, just asking, it's in a scenario where their policy is that they have verbal warnings as one of the potential sanctions. And that verbal warning given at the start will sit on someone's file for 6 months in this case. They're sort of asking for our take on that. I mean, my view would be that that's perfectly acceptable. I don't know, Alison, do you have a view on that?
I think all of these things are context dependent, right? Depends on the industry, depends on the role. I think a warning or a PIP should generally be tailored to how long it will realistically take for an employee to show improvement if they are going to show improvement. So that's going to come down to sort of the business cycle, how measurable it is. But my initial reaction is that sounds completely fine. But happy to discuss it more individually if there are still doubts.
Yeah, absolutely. And that's the theme of today. If anyone's got any other questions that we don't cover today, absolutely get in touch with us afterwards.
The only other thing to add on that I suppose it is going to extend the period of monitoring if you've got that verbal stage built in, and there's nothing to say that you have to give a verbal warning necessarily, because it will be based on, as Alison said, the circumstances. So just throw that in as well.
Yeah. That is a nice segue, I think, to my next question really for you, Meredith, which is, timescales. Timescales are a big part of these processes. And a big question I get from clients, as we all do, is, well, how long has this got to be for? What's the timings? What's the law on it?
Yeah, it's a fact. Lawyers are apt to say this is a fact-sensitive question. Will depend on the role in question. I had a recruitment client recently say to me, we're going to give this chap 2 weeks to improve, and then we think we want to dismiss him. So I sort of talked them down from that position. But if your policy provides for a period, then you should adhere to it. But tribunals don't adopt what is rather highfalutin called a tariff approach to the timescale question. But it will focus instead on the nature of the role and what is reasonable. So if we're concerned with someone working in software sales, I think one of you mentioned, you keep it to perhaps the sales cycle, unless it's an annual sales cycle. But if it's a quarterly sales cycle, that will make sense for you to link the timescale to that as a reasonable part of the process, the business cycle. The extent to which relationships with a customer or third party are affected by the underperformance can also affect it, because you might say, well, that's quite critical. We need things to improve very quickly. Seniority and past experience also will speak to how quickly someone should improve. An example, a very old case, actually, Winterhalter and Gastronome. This was a case that said that a period of 3 months was considered suitable for a senior sales director with 3 years service. And so a tribunal will take a view on what is reasonable. It's that word reasonable again when it comes to timeframes.
Okay, so it's quite a wide word, isn't it? Reasonable. What can you give us any factors that underlie that?
Well, chance to improve is the obvious one.
Yeah.
Unless it's a single act of gross incompetence, which again we'll come on to, but you need to be able to demonstrate that you've given that person an opportunity to improve. At least 2 warnings, I think, is what ACAS says. Support and training. Now, change of a computer system or implementation of new processes, and then coming down on someone quite hard for not necessarily understanding them isn't going to help you. So you need to think about whether there are any failings on the part of the business contributing or causing to the issue. So to give an example, let's say an individual's role has changed from one where they're on the road, visiting sites to a predominantly desk-based job where they have to use new software, as does happen. They're likely to require training to assist them with that adjustment. If you fail to train that individual in the software, then any resulting underperformance could be questionable. And we can see that in the case of steel print. I mean, we can put these cases up, but they're only of sort of general application, where an employee failed to meet the required standard of efficiency in typing following the introduction of a new computer system. It's quite an old case, that one. But her employer failed to provide her with any training, so the decision was unfair in that case.
Perfect, fine. Just to quickly dip in, so we've had another question. I think it's quite a good one. What do we do if there is a change of manager halfway through an ongoing PIP? It's not reached the end, and actually the second manager has a slightly different view in terms of performance. Well, if I can answer that one, my view would very much be, this is, if you've got a HR team in that organisation, one of the areas where HR team, I think, can really assist. And what I would be doing is, it's a question of communication and joined up thinking between those managers. And I think HR can probably sit in between those two and really help facilitate that to ensure that there's a sort of smooth transition between the two. So, it sounds corny, but communication is really important in that scenario. I think it's sitting down, perhaps with HR and the two managers, going through the concerns the previous manager had, talking about the views of the new manager, and just smoothing over that transition. Ultimately, I do think the new manager coming in, as long as that person is reasonable, they've got to be honest in their own views. If the person is improving via this process, then that is what you'd be hoping for in most cases. So hopefully that answers that question.
I mean, you'd also be looking at why the management changed.
Yeah,
this is all fact sensitive, but there may have been a concern with the first manager. I mean, that's often. Appraisals and things are obviously very sensitive, and the recipient of an appraisal is going to be either overjoyed or unhappy with the outcome, and may allege that the outcome is unfair. There may be other reasons why the manager has moved away from that individual's line management responsibility, but I think, as Alex has said, if there can be communication, the new manager is entitled to their own view, but I think would reasonably look at the previous manager's feedback and see whether there was any basis for it, and monitor that going forward.
Yeah, absolutely. Okay, Alison, could you just run through for me that obviously dismissal is a key outcome. Are there any others?
So, of course, we're skipping ahead a bit here, but I think, as we keep saying, that's because your process and how it proceeds is going to be very, very fact sensitive. But in the real world, inevitably the process is going to result in one of two outcomes. Either the individual's performance is going to improve enough, or perhaps they get a new manager, or it doesn't, and then their employment is terminated, or you're looking to terminate it and clear that that's the right outcome for the business. I am going to note, though, before we move on to that, a couple of less common alternative resolutions. So there may be some situations where it's reasonable to impose an alternative role or a demotion instead of dismissing an employee. You're going to need to take care that that doesn't amount to a breach of contract, because that's, of course, the risk in imposing something like that. You might be able to justify it as having reasonable and proper cause. Again, I'm going to say it's one of those times for legal advice, not just because we can give the advice. It might be appropriate, for example, in a case where an individual has demonstrated they're unsuitable for a management role. Perhaps they're recently promoted and it's clear that they can't quite make the leap. The employer might reasonably, in that case, impose a non-management position at a lower grade, that fits the skills the employee has proven that they do have. Or alternatively, you might reach agreement with the employee on a new role, in which case, your contract concern goes away as long as it's, documented and done properly. Or, and this is a stretch here. It's something like, it would be hard to consider a circumstance where it would, probably be the best outcome. Dismissing and re-engaging the individual on new terms, again, complicated and something to consider in detail. Those alternatives are complex, they're risky, they might be great options, in your individual case. But again, I'm going to say again, we'd recommend legal advice if you are, thinking along those lines.
Yeah. Okay. I think another question to Alison. We all spend a lot of our time. We've obviously talked about the process that you should be following, but a lot of our time is spent understanding the sort of commercial realities of our clients and what they're hoping to achieve. And often a question I get is, well, look, this is going to take a lot of time. I haven't got the time for that. There's commercial reasons for it. How can I fast track this? Can I just have a frank conversation? What's your advice to those types of individuals?
Yeah, I mean, we can talk all day about, exact policies and procedures and, how to get it right if you're headed to a tribunal. But because of the complexity of that and because of, as you say, speed and business reasons, it's common for employers to want to put forward a proposal for, an agreed exit. That would generally be called a Section 111A ERA 1996 protected conversation, a bit of a mouthful.
Catchy.
Or sometimes, although there's slightly different things under the law, but we'll skip over that for today, without prejudice discussion. And, in either case, it needs to meet certain requirements in order to be a valid means of resolving the issue without, further increasing your risk of litigation. If the employee is interested in reaching an agreement, there would generally be a settlement agreement, often prepared by a solicitor, setting out all the terms and conditions, that are required by both sides and agreed. It would almost certainly always involve a payment to the employee beyond their, the payment that would legally be required to make to them in those circumstances. That's the point of it for the employee, really. And of course, in return, among other things, you would have the employee's agreement to waive any potential legal claims. So you would know that risk was resolved. A good time to suggest a protected conversation might be at the outset of the process. Once you've informed the employee that you're considering embarking on a PIP, don't do it before, but a discussion for another time. Or alternatively, shortly before dismissal, once you've sort of provisionally decided that that is the realistic alternative. There are risks and benefits to both approaches. So again, you're going to be sick of me saying it. It's an issue you would really be well advised to take legal advice on before you proceed.
Yeah, I mean, we've all seen that go wrong. But putting that to one side, I think it's such an important tool that needs to be considered at a very early stage, because actually having a sensible conversation off the record or without prejudice or other conversation can resolve an issue in quite an amicable way sometimes, rather than it dragging on. So definitely worth considering. All right, Meredith, can you take me through some of the sort of more tricky issues then surrounding these circumstances that arise?
No, absolutely. Someone's just arrived back on my drive with the radio blaring, so sorry about that. If you can hear that. Common issues include someone goes on sick. You might say, well, that old chestnut, but obviously we can't impugn this if they get a sick note and from a GP and so on. You can't really look behind it. If that happens, you could consider alternative means of conducting a meeting. The process overall, for example, by holding telephone meetings, or as we're all used to, this sort of virtual setting, which some people may or may not enjoy, but it's a way of conducting things efficiently. Another thing that we'd consider, and it's absolutely fine, is written submissions. Now, of course, it gives the individual more time to set out their thoughts, which might actually be helpful. It also gives you an opportunity to set out your thoughts as well, without being in that, let's say, extempore environment where you might say something injudicious. If an individual persistently refuses to attend a meeting or participate in the process, then you don't have to postpone indefinitely, and you propose alternative dates several times if necessary at the point until the point at which you think, well, this is just not going anywhere, and then you've also got the settlement agreement route to fall back on.
Yeah.
It is unpalatable to dismiss in what we call in absentia, and I've only really ever seen that once or twice, and it always then led to a subsequent settlement discussion, I've got to say. But in rare cases, you might be justified in doing that. If the individual relies on medical reasons for non-attendance, then consider getting a letter from their GP or their OH specialist to assess whether they're fit to participate in the process. I had a case recently where I think OH had said that the individual was not fit to have any form of business conversation, which does make things very difficult in that case.
Perfect. And if I can just put one further, just a quick question, because I'm conscious of timing, to you. So let's say it's a really severe act of incompetence. Is one act enough to dismiss?
Rarely, but I think we're talking about, I don't know if you've seen the series Chernobyl. I mean, it's somebody working in a nuclear power plant, or a pilot, let's say, which was the case in Alidair, where Captain Taylor was suspended for flying, and he landed the plane so roughly that it caused damage to the aircraft, and he was a passenger carrying aeroplane. And that was a case where the Court of Appeal felt that the required professional level of skill was so high that one small departure from that high standard and a failure to perform can warrant dismissal. But as I say, that is in the very extreme example cases. Perfect.
And a question to you then Alison, and I think this is one of the tricky issues, is what is the issue if a disability is identified during this? And this actually brings me on to one of the questions that we've been asked, so I'll put that to you as well. The question really is, if you have someone who is facing performance-related concerns because they have exhibited in the past aggressive and just generally inappropriate behaviour, but that person then indicates that they have some form of neurodiversity, which is a really common issue that we deal with now. They don't have a sort of formal diagnosis of that at that stage. How would that change the way that you might operate? So as two questions there really for you. It's like looking at disabilities once they're identified, but also in neurodiverse circumstances, how would that affect it?
So, of course, many employees do have a disability. You know, by some estimates, quite a high percentage of the population does. It isn't necessarily the cause of or linked to poor performance. So you will need to make sure that you don't make assumptions, or perhaps sometimes, you know, very murkily, even take an employee's assertion at face value. And I think that ties back to what Meredith just said about, you know, the importance of bringing in, you know, people whose, you know, remit and speciality that is, you know, such as occupational health providers. Where performance is caused or exacerbated by a disability, you'll need to comply with, you know, the disability provisions under law. Most importantly, the 2010 Equality Act. For example, you know, considering making reasonable adjustments to support the employee before you consider a capability process. Again, fact-based, but supportive steps might include additional training, additional support, making adjustments during the performance process itself, perhaps, including allowing a counsellor or a family member to accompany the individual to a performance review meeting. So in the case of the question we've had through, my personal instinct is that maybe more of a conduct situation than a capability one, but, you know, the rules aren't necessarily the same for that. I think, you know, there's definitely a fact-finding stage to that. You know, there is no rule that says that you know, if someone has a disability, they absolutely can't be disciplined or dismissed. But you do need to, you know, follow a set amount, you know, set steps to ascertain the impact of the disability, you know, steps that you should be taking to support the employee, you know, the actual link between the behavior or the capability issues and their behavior. I hate to say this, but I think it may be a subject for either a conversation offline or another webinar.
I totally agree. I think the big thing I would say is definitely don't just stop doing anything. That is, if anything, the more important reasons why you should be managing it, you know, trying to ascertain that medical position so far as you can, but don't just stop processes. I do think that's the wrong thing to do.
Everybody's safe.
You might pause them for a brief moment whilst you get information, but that's a different tact. Okay, I want to put a final question to you then, Alison. So a grievance is a really common thing that happens as well. How do we deal with that in the circumstances?
So you're going to need to make a decision there whether you bring that within the scope of the performance management process, or more commonly a disciplinary process. It's more common for there to be murky overlap with with conduct than with capability. Capability is usually, you know, more measurable. Or whether you're going to run a separate grievance process, and then whether you can do the two at the same time or not. In many capability situations, I would suggest you can, but again, you need to look at it and use your judgment. It may be appropriate to deal with the grievance at the same time if there is substantial overlap. I would caution that it's particularly important to do a separate investigation where there's an allegation of bullying by a line manager conducting the performance process. And you might want to think about doing it ahead in that case, or, you know, keeping it separate where the grievance concerns something that just isn't connected with performance issues at stake. And again, I'm going to say it's complex, and I think it's, you know, it's something we'd generally recommend seeking some specific legal advice on.
Fine. Before I end, we've had another further question I'll just touch on really briefly. There's a quick question here saying, does a DSAR request automatically postpone the disciplinary process? I mean, my simple answer to that is no, absolutely. You shouldn't be postponing a disciplinary process because someone's put in a DSAR. You just carry on with the disciplinary process, unless there's really close interrelation between the two. But I don't think I've ever paused a disciplinary process because the DSARs come in, and I wouldn't generally recommend
them as completely unrelated.
I mean, I answered the question as well, thankfully, largely in line with what you've just said.
Well, that's good privately.
But I said no. Not generally, as the DSAR regime is a standalone, and this would not be one of the ICO exceptions. But you may, however, have wider commercial / prejudice concerns. For example, if the documents obtained in the DSAR cause a problem for the outcome. So in this case, you should say might look to delay the DSAR as a time. But I mean, you can't really. I mean, we're at that they are separate.
Okay, well, we've had quite a lot of questions there, and I think I've managed to get to all of them. If I haven't, I do apologise, and do get in contact. We're more than happy to talk to anyone here today. So My hope is that you found this session quite interesting. I think, Meredith, Alison, you've been brilliant in terms of going through some of those tricky topics. As I say, get in touch. You've got any employment law inquiries, you can visit our website, which is www.thomasmansfield.com. In addition, we try to make these as meaningful as possible, so we really, really like feedback, and even better than feedback, we really like requests for certain topics, because if you put in a request, we'll look at that and we'll maybe do a webinar specifically on it for you. So do feedback. We've got some good events coming up as well, just to mention those if you've not already seen them. So what have we got coming up? We've got an in-person lunch club on the 18th of October. That's taking place at our city offices near Bank in London. And that is planned to be quite an interesting one. It's a smaller group of people. We're going to have an interactive workshop. I'm involved in that one. And we're gonna deal with the tricky issues of managing sickness, and we're going to deal with that head on. So that should be quite an interesting one. Secondly, we've got a 16th of November. That's our next webinar in this format, and that's going to be looking at a bit of a roundup of employment law, case law over the last year, and lessons that for employers. And what I'm going to do, I'm going to try and be clever here, and copy a hyperlink, which should hopefully come up for everyone. Hopefully you can all see that on there. So if you click on that, that's your route to go through to the training events, but they're all on our website generally. Thank you for everyone attending, and I'm sure we'll be speaking soon to many of you.
Thank you.
Many thanks. Bye-bye.